let's talk about how these evaluations differ from one another. In qualifying examinations, the threshold, as you may recall, is that all candidates in the job class must be given the standardized evaluation. In a fitness evaluation, there must be objective evidence of impaired safety or effectiveness, and a reasonable belief that it derives from an underlying mental health condition. So the thresholds are different. In a qualifying exam, the scope is broad. In a fitness examination, it's narrow. It's narrow because the ADA says that in a compulsory examination of an employee, the employer is not entitled to an examination beyond the scope necessary to resolve the underlying referral issues. That is, if you have a person who is has a vision problem, you probably can't get away with doing a gynecological exam or a proctological exam unless he has his head. So yeah, there are limits to it. If you know, for example, that the person has reported depressive symptoms, you're going to want to zero in on the presence of a mood disorder. That doesn't preclude looking at anxiety disorders. The complication, though, comes in this respect, that there's a case, we come to it later, Sega versus Yuba, I think it's Yuba County. Is there a Yuba City?
Yes.
It might be Yuba City. We'll come to it. It's in the materials that we're coming to later. And this is a fairly recent case, I think 2007, where the California Appeals Court, pretty sure it's California Appeals Court, who concluded that, it's either California Appeals or Ninth Circuit, but I think it's California Appeals, who concluded that 1031F is always on the table. 1031F being the criteria for selecting police officers, for qualifying police officers in the state of California, is always on the table. And that 9055, all the post standards, are always on the table. Now that doesn't mean that you're free to do a fishing expedition, that you would just simply do for a fitness for duty evaluation a pre-employment psych and say, oh, the person doesn't meet the pre-employment psych. It is to say, though, that if the particular expression of the person's mental condition impairs their ability to meet the post-10 requirements, that they are relevant. So it becomes the way in which you would judge whether or not a mental health condition impairs the person's ability to perform the duties by using the post standards. Nevertheless, there is a narrowing of the scope in a fitness for duty evaluation, and in a pre-employment, the scope is broad. The methods are also different. In a qualifying exam, the methods are standardized. Use the same protocol for all of your applicants. In a fitness for duty examination, it's going to be case specific. You might use instruments designed to assess PTSD in one case. You might use some neuropsychological examinations in one case, and you might focus on mood disorders in another case. So your assessment instruments may vary. You may add some, your interview may be a bit different. You may have collateral references in some case, or collateral sources in one case and not in others. And that the third-party information typically is limited to the background investigation that's provided to you, and in a fitness for duty evaluation, you will very often engage in your own collateral interviews. You would never do that at the pre-employment stage. You're not going to interview other collateral references, but you may well do that in a fitness for duty evaluation. By the way, I didn't talk to you yet. I should have. If I can just take a, go back to qualifying exams, pre-employment for a moment. The last appendix. I think it's page 110. This is a variation of a form that Mike Roberts was after me for a number of years to consider using for myself, and I had all kinds of reasons in my head for not doing so, but I ultimately developed a methodology that I was comfortable with that borrows a lot from Mike's prior work. So, as always, I stand on the shoulders of the giants in my own innovations. And what this is when a candidate discloses to me that he or she has had mental health care that is recent or that has included significant psychotropic medications, where there are other features that would lead me to believe I need to find out what's going on here. I really don't know that I have a good understanding of what is happening clinically with this person and what this treatment is all about. I'm not comfortable simply saying, I want your mental health records, I want your psychotherapy records. I think that that's too intrusive, and I may not get them. I probably will in a fitness evaluation. I'm probably not in a pre-employment. We'll talk about why I'm confident, fairly confident I can get them in a fitness a little bit later. But returning to the pre-employment, both HIPAA and the most state confidential medical information access statutes provide for much more leniency when there's a job-relevant inquiry that's limited in scope. And the EEOC permits you to inquire of a person's healthcare provider if it is a restricted inquiry. Remember what HIPAA also values, the minimum information necessary. So I'm only trying to get at the really job-relevant part. So the first page is the instruction to the mental health treatment provider. Tells them what I'm looking for and why I'm looking for it. The next page is a HIPAA and, in my case, Oregon State compliant release or authorization form that the applicant completes. They are responsible for taking this form or sending this form to their healthcare provider or providers. It might be a psychologist they're seeing and a nurse practitioner or physician that's prescribing medication. And I write down on my form that a judgment about that person's qualification is pending the receipt of these forms from X number of providers and the following names. And then my staff knows that when they come in, when they're faxed in, then they give me the file back and I complete my assessment. And among the, or in this form, they are asked to answer yes or no with appropriate explanation to 20 questions. God, I like 20 questions, so. Yeah, I think that's my limit. I like 20 questions, that's it. After that, so 20 questions. And then they provide explanation on the next sheet. Now, I'll tell you, most of the time, and I'm sure this is true for you, Mike, as well, most of the time when I get this form back, the person's qualified and we move on. Everything's really fine. If I'm going to find them unqualified, if I already know I'm going to find them unqualified for reasons that have nothing to do with us, I'm not asking for medical information. Why complicate it? I'm just going to make a determination the person's unqualified. But if they would otherwise be qualified, if there's no new problems resulting from the medical information, then I'm going to ask for this information. And yes, Justin.
In terms of sort of SOP,
yep.
In terms of procedure, why would you differentiate, aside from saving time, in not asking everyone for medical records if the question comes up? And saying, you know, those you know you're going to DQ, I don't want that information. Why would you deviate from your standard protocol?
Why did you make me provide records, but you didn't make her provide records?
Yeah, I agree with Jocelyn.
Well, if I know that I'm going to disqualify you,
I don't need it. I mean, I understand.
why would I intrude your privacy? You're toast already.
Well,
you can't untoast you You're done.
Is it privacy versus your protocol?
No, it's privacy. I mean, I'm not,
It's not necessary to.
it's not, it's unnecessary. It's not gonna move you from an unqualified candidate to a qualified candidate. So I'm not gonna invade your privacy.
Okay, I mean, that's a good reason, but that would be the reason.
Oh, yeah. I think it would be totally inappropriate for me to ask to see your medical records or to ask your medical provider to fill out these kinds of questions if there's nothing you can do to revive your qualification. You're done under
It's
any
not relevant
circumstance.
to your
It's
decision.
totally irrelevant to my decision, yeah.
But
Jenny first, and then Joe.
I was just gonna say, I can see that, and sometimes I struggle when I know I'm not gonna pass the person, and I'm waiting on these therapy release forms to come back. But I'd rather have as much information as I can, so that if I'm challenged, then I have a basis for saying, yes, there really was significant emotional instability.
Well,
So it's
so
interesting that-
Jenny would say that she would do it, Jenny says that she would do it anyway, and listen, you may be right about it, Jenny, and I'm not suggesting that my answer, I'm just telling you why I
Yeah,
do
it's
it
just
the way
the
I do it.
contrast is interesting.
And I place a pretty high value on privacy of psychotherapy and psychological mental health treatment. So I only want it if I think that it might be relevant to my determination. It's not, I'm not making it right, but also if I really am, and most of the time I am at this point, finding the person unqualified on the basis of non-medical information, why would I complicate it by including in my assessment true medical information?
But it's sort of like the equivalent of if I get an invalid PAI, I know I'm not passing that person, but yet I still do the thorough evaluation. So I mean, I respect and appreciate your point of view. I just see it as a full piece of
But there
doing
are
a thorough
qualitative
eval.
differences between doing an evaluation, which I would normally do with everybody,
Right.
versus one in which I'm inquiring about their personal health information. Joe?
just, I think a possible vulnerability, if you've got two applicants, one, and they both have medical information available, and you get one from one and not one from the other, there's a vulnerability of violating your own protocol and procedure.
Well, except that if my protocol and procedure is as I described it, so Joe's statement was, if I don't ask one applicant for medical information and I do for another, I violated my procedure, except that my procedure does call for not asking for medical information on people who I've already deemed to be unqualified no matter what their new medical information is.
From a legal point of view, I'm not an attorney, I didn't say the Holiday Inn, but you're still open, I think, to
Sure, yeah, I'm still open to
being
criticism.
sued or
Yeah,
killed on the
okay,
basis.
one more question on this, and then we gotta move on to other topics.
Well, the same issue came up from my colleague was saying, if you did your initial test and it was invalid, but as you're reviewing the background, you realize I'm DQing this person anyway. They're a mess. They were ugly in this way, this way, this way. Do you necessarily give them another test if you know you're going to DQ them anyway?
You give them all the tests at the same time.
In essence, she gives like the MMPI and the 16PF. Let's say they're invalid. But in the meanwhile, she's also reviewing the background, and based on all the information she's collected so far, she's going to DQ them. So she would say, we're not going to give them now the PAI, because
she
I
might give
already
them the
know
PAI.
I'm going to DQ them.
That's-
It's almost the same type of
Okay,
argument.
so you're saying that in the procedure at Riverside Police Department, if incremental evidence comes in through psychological testing that would lead you to disqualify a person,
No, if the test data is invalid.
oh, the test, well,
The test data is
Right.
invalid,
That's
but there's
disqualified.
so much already in the background and that you know you're not going to pass this
but,
person.
so we are saying that as data comes in incrementally, and you determine on the basis of that particular data set, you're not gonna qualify the person, you don't continue to gather more information.
Yeah, that's why it
Okay.
came up for me, because it seems like it's the same issue
Yeah,
you're
I
talking
mean,
about.
I would probably have more angst about that than I would about
Yeah, I do.
my own truncating of the process. But I hear you, and I will think about it. I will think about it. But that's the reason why I don't, is that I don't want to invade privacy. I think that there is a value in, as reflected in the EEOC guidance, for not intruding on medical information any more than is necessary. So that's the rationale for it. Back to fitness for duty evaluations. Where do they come from? Well, there are a number of different reports that give different information about where they come from. Tony Stone's book, 2000, he articulates where they come from in a presentation a few years ago, I think 2005, 2006. Dawkins and Griffin and Dawkins at IACP gave a presentation on the sources of fitness for duty evaluation referrals. And here are my own data. Approximate. Off-duty behavior, domestic assault, menacing, telephone harassment, sexual impropriety, DUI, things of that sort, about 25%. Suicide threat, suicide attempt, behavior that would lead a person to believe that they were suicidal, about 15%. On-duty behavior, including excessive force, safety concerns, serious interpersonal problems, gross neglect of duty, about 20%. And then an independent medical examination, and by that I mean the person has been released to return to work by the treating healthcare provider after a stress claim, or their healthcare provider has requested a reasonable accommodation and the agency wants an independent evaluation of whether or not that accommodation is called for, about 40%. So the single largest category is the latter. How does that generally mesh with your own fitness for duty evaluations? Similar kinds of referral sources? Okay.